hello, welcome, and it seems appropriate to say Namaste. Well, welcome to our yoga studio, well, a virtual one at least. My name is Peter Afrasayabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is from our Curious Lawyer series and is a look at where yoga meets the law. We explore brutal litigation yoga battles between yoga companies, the folks you would think are the most peaceful ones imaginable. And we look at city efforts to stop yoga on the beaches. Yes, really, bans on yoga on the beaches. And in my home state, in California no less, the place that supposedly is most enamored by and tolerant of yoga and modern spiritual and exercise-based practices. Substantively, this yoga law program will let us look at a variety of issues then from the realm of copyright law and also then the First Amendment. So you will get a good primer overview of both areas of the law before we dive into our yoga wars. So grab your yoga mat, and as they say in yoga studios, let's start with an intention, which for us means we will start learning about yoga poses and an overview of copyright law. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you. A true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs. And, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education. That is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking ethics exploration of our judges. Let's start with our agenda in our program on yoga and the law. We will look at yoga studios and litigation over yoga poses and who owns them. We will look at cities banning yoga on the beaches. This will take us substantively into a good overview of the basics of copyright. We will cover the issue of what is copyright. How does one get a copyright? What are the elements required? What is the line between expression that copyright can protect and an idea or system that is outside the bounds of copyright? Then when you have a copyright, what are the rights that you as a copyright holder possess? And what is the basis to compare a new work to an existing work to decide if there is infringement? Specifically, as we turn to our yoga battles, we look at copyright protection for choreographed routines and how they gain protection, its limits, and where systems or ideas fall outside protection. We thus will look at the scope of protection from instruction manuals detailing yoga poses and yoga practice flows. We also will get an overview of First Amendment law as we assess cities banning yoga on the beach and the legality of such bans within the First Amendment. This will take us to the First Amendment, early cases exploring how it works, and its applicability to the states. This takes us to a primer on the viewpoint and content-based restrictions standards within First Amendment law. And that will then allow us to look at city ordinances banning yoga on the beaches. Let's look quickly at the issues we will be confronting and the answers you will get later as we work through the principles. You see here a flowchart of 26 yoga poses so you can understand the issue we are exploring through copyright law. Those are the poses and sequence of doing them that one of our yoga warriors sought to control and stop others doing. For our copyright and yoga segment, the issue as framed by the Ninth Circuit was as follows. Quote, "We must decide whether a sequence of 26 yoga poses and 2 breathing exercises developed by Bikram Choudhury and described in his 1979 book, Bikram's Beginning Yoga Class, is entitled to copyright protection." End quote. The question, then, that warring yoga studios have raised in the courts is as follows. Can those sequence of poses be monopolized via copyright law to the exclusion of others using the same poses in their yoga teaching materials? Does a copyright in the book that shows the poses extend to the actual sequence itself? Or is the set of sequences a system or idea outside the bounds of the copyright monopoly? Out of the gate, for those of you who have not done yoga, let's get some definitions out of the way. Here is what yoga is, well, at least as the courts have described it. And if to you yoga masters watching this, it is inaccurate or incomplete, my apologies. I have taken as I must the working definition from the legal cases, as this is a CLE after all. Here is what the Ninth Circuit has said in its yoga battle case we will be looking at. The Indian practice and philosophy of yoga date back thousands of years. Derived from ancient Hindu scriptures, the practice of yoga teaches students to attain spiritual fulfillment through control of the mind and body. Yoga has evolved into a diverse set of spiritual, philosophical, and physical disciplines. Some students practice yoga to transcend the physical body and unite with divine powers. Others focus on improving strength, flexibility, and overall physical fitness. The history of yoga in the United States reflects its wide-ranging appeal. Some of yoga's first American adherents included 19th century transcendentalists, such as Henry David Thoreau and Ralph Waldo Emerson, who were fascinated by yoga's approach to achieving enlightenment. In the early 20th century, yoga grew more popular as scientists and physicians began to study the physical benefits of the practice. These physical benefits caught the attention of Hollywood celebrities, Greta Garbo and Marilyn Monroe, who embraced yoga as a tool to fight illness and aging. Now our plaintiff in our coming case is Bikram Choudhury, the self-proclaimed yogi to the stars. In 1971, he arrived in Beverly Hills, California. He soon became a central figure in the growing popularity of yoga in the United States. So that gives you a good definitional overview of yoga. Now here you see some people practicing yoga on a beach in San Diego, which brings us to our second situation, our First Amendment situation we will explore. This takes us to 2024, where the city of San Diego decided to take on public yoga on the beaches. San Diego passed a municipal code ordinance that defined teaching yoga as a non-expressive activity and prohibited the teaching of yoga in shoreline parks and beaches without the city's permission. 2 yoga instructors were cited for teaching yoga on the beach. They sued in our case here. The basic fact pattern is the picture on this slide. and whether that can be regulated as conduct subject to police power or whether yoga teaching is expressive First Amendment activity. So the question we will answer, did San Diego violate the First Amendment? Stay tuned. To answer our questions, we must now backtrack and get a quick copyright and then First Amendment overview. Let's start with copyright and ask, what is it? Copyright protects original works of expression that are fixed in a tangible medium. Those are dual requirements for copyright to then attach to the creative work. These two requirements are the root of copyright, both originality as well as fixation. Let's now unpackage both of them. Let's take the very first requirement, known as originality. It simply means that the creation is original to the author. This is not a requirement of something that is new and novel and never before seen. It simply means that it is the original creation of the author at issue. The bar for originality is very low. It essentially means that there must be the most minimal creativity and copyright will attach. For example, if you are watching this and doodling a pretty cool doodle on a piece of paper, you are creating a copyrighted work in this moment. Why? Because it is an original work of expression made by you, and it is also being fixed in a tangible medium, specifically the pen to paper. But before we get to the fixation requirement, let's talk a little bit more about how courts approach the originality requirement. Courts generally do not want to get involved in making any kind of artistic determination about the artistic merit of a creative work. This is a long-standing policy in copyright law which goes back over a century to the Supreme Court. It is indeed a fundamental bedrock principle of copyright law today. The rationale for this rule was expressed long ago by the Supreme Court when it indicated that courts will not wade into artistic determinations because they are not equipped, and will on one end deny protection to things that are artistic, and on the other end give protection to things that may not be sufficient. This is what Justice Holmes said at the turn of the last century in the early 1900s. Quote, "At the one extreme, some works of genius would be sure to miss appreciation. Their very novelty would make them repulsive until the public had learned the new language in which their author spoke. It may be more than doubted, for instance, whether the etchings of Goya or the paintings of Manet would have been sure of protection when seen for the first time." At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge. Yet if they command the interest of any public, they have a commercial value. It would be bold to say that they have not an aesthetic and educational value, and the taste of any public is not to be treated with contempt. End quote. Another underlying theme is that, when it comes to creative works, very few things in the most abstract sense are truly new. Here's another quote from way back from Justice Story. Quote, "In truth, in literature, in science, and in art, there are and can be few, if any, things which, in an abstract sense, are strictly new and original throughout. Every book in literature, science, and art borrows and must necessarily borrow, and use much which was well known and used before." End quote. So that is originality. This brings us then back to the fixation requirement. The Copyright Code's language is that it must be fixed in a tangible medium, which is legal language that means it must be recorded in some permanent fashion. This means pen to paper, oil on canvas, typing on a keyboard into the memory of the computer, or molding a piece of clay into a sculpture. What it also means is that if you come up with a fantastic little love poem and hire one of those skywriting airplanes to put it in smoke in the air for your loved one, you have not fixed it in any permanent form, at least in that fashion. Key practice pointer. Today there is no registration requirement to have a copyright. It exists at the moment of creation. But to sue for infringement, you do have to register. Thus, sound advice is to have clients register their works. It is also relatively cheap to do at the Copyright Office. There is a second related practice pointer here that relates to registration. Specifically, registering before a work is infringed gets you access to powerful statutory damages remedies. Specifically, if your client timely registers, then they can get statutory damages of up to $150,000 for an infringement if it was done willfully, as well as attorney's fees. Or if it's not willful, you can still get up to $30,000 plus attorney's fees. This is a powerful remedy that is essentially divorced from actual market harm or damage, and so is a very powerful damages and remedies weapon that makes registering very valuable. So, again, as a practice pointer, it is good to advise your clients who are creating works to register the copyright upon creation or publication. These are the two fundamental pole stars that frame the threshold copyright inquiry. So, yes, if indeed you are drawing doodle pictures as you listen to this, well, your doodle is becoming your copyrighted artistic creation right now. This brings us to the question of what types of works fall within the realm of copyright. Copyright protects books and other writings, music, of course, which we will be talking about today, movies and films, photographs, artwork, software, and source code, even architectural works and clothing, designs, as well as pantomimes, choreographs, and plays. This is just an illustrative list and is not exhaustive. And we bolded in red the idea of choreographs, as that abuts what we will explore with the sequence of yoga poses case that we are looking at. So you now have a copyright, but what does that mean exactly? What are the exclusive set of rights you have? This is answered by federal copyright law again. And as a side note, federal law is the exclusive depository of laws that relate to copyrights, and it preempts state laws in this area. So let's look at the exclusive rights that you as a creator or author have under federal copyright law. There are several specific ones you see listed here as the exclusive rights to do and to authorize any of the following. 1. To reproduce the copyrighted work in copies or phonorecords. In simple terms, this means to make copies of something, such as photocopying or cutting and pasting or downloading. 2. To prepare derivative works based upon the copyrighted work. In simple terms, this means to make new works from the original. Think the James Bond novels, or when George Lucas made Star Wars. He had the right to make sequels, prequels, and other works based on Star Wars. 3. To distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. 4. In the case of literary, musical, dramatic, and choreographic works, pantomimes and motion pictures and other audiovisual works, to perform the copyrighted work publicly. And for today's program about yoga and yoga poses, this is the right and scope of this right that we will drop into. 5. In the case of literary, musical, dramatic, and choreographic works, pantomimes and pictorial, graphic, or sculptural works, including the individual images of a motion picture or other audiovisual work, to display the copyrighted work publicly. 6. In the case of sound recordings, to perform the copyrighted work publicly by means of a digital audio transmission. These are the codified exclusive rights. You have a copyright and those exclusive rights. What if you think someone has infringed you? How does that work, and what are the infringement principles? Basically, the overview is as follows. A plaintiff must show ownership of copyright and that the defendant copied protected elements of the work. Now, because direct evidence of copying is hard to find often, a plaintiff can show copying by access and substantial similarity. What does that mean? Substantial similarity is necessarily imprecise in the law. We will unpackage it in a moment. But here is an important concept that recurs in the law. Upon any work, and especially upon a play, a great number of patterns of increasing generality will fit equally well, as more and more of the incident is left out. The last may perhaps be no more than the most general statement of what the play is about, and at times might consist of only its title. But there is a point in this series of abstractions where they are no longer protected, since otherwise the playwright could prevent the use of his ideas, to which, apart from their expression, his property is never extended. That comes from the case of Shaw versus Lindheim from the Ninth Circuit in 1990. Substantial similarity studies and analysis works as follows. To assess whether there is copyright infringement, courts employ a two-part test known as the substantial similarity test. It varies slightly by circuit, but here is the Ninth Circuit's formulation. As the Ninth Circuit held in Antonic versus Electronic Arts at 841 F. 3rd 1062 from 2016, the court employs a two-part test for determining whether one work is substantially similar to another. Specifically, a plaintiff must prove both substantial similarity under the extrinsic test and substantial similarity under the intrinsic test. The extrinsic test is an objective comparison of specific expressive elements. The intrinsic test is a subjective comparison that focuses on whether the ordinary, reasonable audience would find the works substantially similar in the total concept and feel of the works. Now, the extrinsic test is one of law for the court, so is often adjudicated on a motion to dismiss or summary judgment motion. If a plaintiff survives that gauntlet, then the jury will decide it as well as the intrinsic test. Within the intrinsic and extrinsic tests, the court must be careful to address the idea and expression dichotomy we discussed earlier. The court must instruct the jury as to 1. The non-protectable elements of the plaintiff's work, and 2. The appropriate standards, such as are they virtually identical or substantially similar, and 3. That the jury may consider the work as a whole. That is black-letter law. If you want a good case on this, check out Apple Computers versus Microsoft Corporation, reported at 35 F. 3rd 1435 from 1994 in the Ninth Circuit. What are those expressive elements courts look at to do this test? For example, the test for literary-based creative works focuses on articulable similarities across plot and sequence of events, the theme, the setting, mood, pace, dialogue, and characters. For plot and sequence of events, courts look past the general abstract idea of a plot and look to actual plot elements. For a theme, courts ask what are the themes and how are they explored? Where is it set? What is the mood of the works? Is it triumphant, sad, angry? Are the sequences fast-paced or leisurely? On dialogue, a court looks for actual content similarity in character dialogue. Regarding characters, look to similar characters and character traits and relationships between characters. Of course, other factors are relevant to other kinds of creative works, such as if you're in the realm of photography. Remember, within the intrinsic and extrinsic tests, as I said earlier, the court must be careful to address the idea and expression dichotomy we discussed earlier. It needs to filter out unprotected elements and stock general ideas that belong to all. And the devil in the detail is often found in that filtering out process. Now let's take all this to our yoga wars. This is the case from the Ninth Circuit where the largest yoga war erupted. There is the case citation for you, and here are the facts. Recall, Plaintiff Chowdhury developed a sequence of 26 moves and 2 breathing exercises, arranged in a particular order, which he calls the sequence. He opened his own studio where he began offering Bikram yoga classes. In a Bikram yoga class, the sequence is practiced over the course of 90 minutes to a series of instructions, which he called the dialogue, in a room heated to 105 degrees Fahrenheit to simulate native Indian climate. He informs prospective students that his system of Hatha Yoga is capable of helping you avoid, correct, cure, heal, or at least alleviate the symptoms of almost any illness or injury. He claims that he developed the sequence after many of years of research and verification using modern medical measurement techniques. This brings us to the students. 2 of his students started their own yoga business. They acknowledge that their hot yoga includes 26 postures and 2 breathing exercises and is done for 90 minutes, accompanied by a series of oral instructions in a room heated to approximately 105 degrees Fahrenheit. Plaintiff was unhappy. He then claimed that defendants infringed Bikram's copyrighted works through substantial use of Bikram's copyrighted works in and as part of defendants' offering of yoga classes. So let's go to our principles and analyze this. What is not copyrightable? Section 102(b) of the Copyright Act expressly excludes protection for any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. What is the point of this? Well, this codifies the idea-expression dichotomy, under which every idea, theory, and fact in a copyrighted work becomes instantly available for public exploitation at the moment of publication. This idea-expression dichotomy strikes a definitional balance between the First Amendment and the Copyright Act by permitting free communication of facts while still protecting an author's expression. Thus, for example, recipes contained in a copyrighted cookbook are not entitled to copyright protection, for they merely describe a procedure by which the reader may produce many dishes. And there can be no monopoly in the copyright sense in the ideas for producing certain foodstuffs. That comes from this Seventh Circuit case you see here. So the issue then in the yoga war was as follows. Does the copyright in the plaintiff's book extend to the 26-pose sequence itself as an independently controllable thing? But before we give you the Ninth Circuit's answer, let's listen in on part of the oral argument before the panel to see the judges in action asking their questions that frame this issue.
Was the sequence registered with the Copyright Office?
Yes, it was, Your Honor.
Can you show me the registration form for the sequence?
It is registered first in the I believe it's 1979 copyright for the book Bikram Yoga Asana. I'm sorry.
And that was for the book. That's what you're talking about.
That is correct. And then the Copyright Office, Bikram subsequently attempted to register the sequence on its own in 2002.
The Copyright Office rejected that.
That's right. They rejected it, but what they said was that there's a number of statements.
I think you're referring to the supplemental filing that described the author as the author of the sequence, but that did not serve as registration of the book. I mean, of the sequence. It's related back to the book.
That is correct, but as the Copyright Office explained, the sequence is first fixed in the book, and it's inseparable from that text.
You can't copy the expression of the sequence that's in the book. That doesn't mean that the sequence has a separate and independent registration or a separate and independent copyright.
It does not have necessarily a separate and independent copyright, but that is in fact not the relevant question. The question is whether the sequence has a recognized copyright, and it does. It has a recognized copyright in the 1970s.
I think that argument really stretches what a registration is. It's not registered separately as a work of art fixed in a tangible means of expression. The only place in which it's fixed in a tangible means of expression is the book, or maybe some video or something that is also copyrighted. But just because you can copyright a book that contains some uncopyrightable elements doesn't mean that the uncopyrightable elements become the subject of copyright by that registration.
So you heard Judge Wardlaw ask those questions. And here, then, is what the Ninth Circuit held in their two-part holding. The sequence is an idea, process, or system designed to improve health. Copyright protects only the expression of this idea, the words and pictures used to describe the sequence, and not the idea of the sequence itself. Because the sequence is an unprotectable idea, it is also ineligible for copyright protection as a compilation or choreographic work. Specifically, an essential element of this system is the order in which the yoga poses and breathing exercises are arranged. Bikram's beginning yoga class instructs readers, do the poses in the strict order given in this book. Nothing about Bikram's beginning yoga class is haphazard. It is designed to scientifically warm and stretch muscles, ligaments, and tendons in the order in which they should be stretched. For instance, plaintiff explains that the yoga camel pose stretches the abdomen and compresses the spine. So for the next posture, he chose the rabbit pose, which does the converse. It stretches the back and compresses the abdomen. Accordingly, the balance between monopoly and, on the other hand, other people's right to free competition is critical. Now, this is true even though the same benefits could be achieved by doing poses in a different order. The result is that one cannot monopolize a series of yoga poses to the exclusion of others teaching and offering them in the same way. What is a choreography? It represents a related series of dance movements and patterns organized into a coherent whole. The sequence of them together is not copyrightable as a choreographic work for the same reason that it is not copyrightable as a compilation. Specifically, it is an idea, process, or system to which copyright protection may in no case extend. Thus the court held. We recognize that the sequence may involve static and kinetic successions of bodily movement in certain rhythmic and spatial relationships. But so too would a method to churn butter or drill for oil. Our day-to-day lives consist of many routinized physical movements, from brushing one's teeth to pushing a lawnmower to shaking a Polaroid picture, that could be characterized as forms of dance. Without a proper understanding of the idea versus expression dichotomy, one might obtain monopoly rights over these functional physical sequences by describing them in a tangible medium of expression and labeling them choreographic works, end quote. So in our yoga wars, the plaintiff lost, but yoga as a whole won because all can teach the yoga poses. Namaste indeed. So there you see how the yoga sequence came out in 2015. Let us now look quickly at a video game sequence case from 2023 that picks up on the Bikram yoga case. This is Hanagami versus Epic Games, reported at 85 F. 4th 931 from the Ninth Circuit in 2023. This case involved a plaintiff's copyrighted choreographic work. Epic Video Games makes the popular Fortnite video game. In the game, people can buy animations for their characters. Plaintiff sued because the animation copied his choreography. He alleged that Epic copied without limitation the footwork, movement of the limbs, movement of the hands and fingers, and head and shoulder movement covered by the registered choreography. He further averred that the tempo is the same in both the registered choreography and the Epic video game character animation. Now, it was dismissed out of the gate on a Rule 12 motion. But here, the Ninth Circuit held here that the particular selection and arrangement of the unique dance movements could potentially get protection. That is, the specific sequences of this choreography was potentially protected, even if each element was not alone. Thus, while individual dance movements may not receive protection, their original selection, coordination, and arrangement may be protectable expression. So, the result is that not all dance choreography is off limits from copyright, but yoga health practice routines are off limits from the copyright monopoly. Let's see how Epic Games distinguished the yoga case. There we considered whether a sequence of yoga poses could be subject to copyright protection as a choreographic work. We held that the yoga sequence was not copyrightable as a choreographic work because it was an idea, process, or system to which copyright protection may in no case extend. Today, we adopt the Copyright Office's Compendium's definitions of choreography and dance. The compendium defines choreography as the composition and arrangement of a related series of dance movements and patterns organized into a coherent whole. The compendium does not draw a bright line distinction between copyrightable choreography and uncopyrightable dance. Instead, there is a continuum on which many works fall somewhere in between. Choreographic works could plausibly contain multiple unique elements, and those elements can and will change depending on the work in question. The task for courts, then, is to compare the selection and arrangement of elements in the registered choreographic work with that in the allegedly infringing work. At the motion to dismiss stage, the court must only consider whether the plaintiff has plausibly alleged that the two works share substantial similarities. So this set of dance routines may be worthy of protection upon a proper fact record past the Rule 12 stage, and not simply be an idea or process, but the yoga ones were not because they were an idea or process. In this sense, it did not overrule or avoid the yoga case. It simply held that the question needed more fact development. Now let's start out review of the city's assault on yoga. This brings us to the First Amendment. Incredible language, short, to the point. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. On its face, it is pretty absolute, and as you recall from law school, Justice Black had a fairly absolutist position on this language. Regardless of that, we have laws restricting speech that are analyzed under a variety of First Amendment tests. So let's get our bearings on the basics of categories of speech that can be regulated. Is yoga one of them? Stay tuned. You see here we have the case of State versus Gruber. This is from Maryland in 1819, and this involved a Reverend Gruber who was a member of the Methodist Episcopal Church, and he preached a sermon at a camp meeting, and this was organized by his Methodist Episcopal Church, and he preached this sermon to around 5,000 white people who are in attendance and around 400 odd slaves. Now, Reverend Gruber criticized slavery as a, quote, national sin, end quote, and said, this is contrary to the founding principles of the Republic. In short order, Gruber, Reverend Gruber that is, was arrested and in a criminal indictment. He was charged with attempting to stir up acts of mutiny and rebellion. It's a sort of an old form in essence of incitement, and the incitement speech issues, which have, as we see now, touched the country from the beginning and touch us even to this day. Now, what happened in this case, interestingly, is that a lawyer by the name of Taney, who later became an infamous Supreme Court justice, represented Gruber and secured an actual acquittal in front of the jury on free speech basis. So the case never made its way up to the Supreme Court, but it's an early example of someone engaging in speech that's deemed insightful and likely to cause problems. And also now it's abolitionist speech, obviously, the massive issue of that day in terms of slavery and abolition. But Taney was able to secure an acquittal in front of the jury, saying that the Reverend had the right to engage in that speech by calling slavery an original sin, and that the prosecution was fundamentally improper because he secured an acquittal. Now, what's interesting is that in many southern states, states then started actually passing more specific laws banning abolitionist literature and speech. And in perhaps great tragic irony, I guess that is the word here perhaps, or just plain tragedy, to the situation this lawyer Taney, who represented Gruber, found himself in. He secured an acquittal of Gruber, allowing him to engage in abolitionist speech. But Taney later, when he was on the Supreme Court, delivered the Supreme Court's infamous Dred Scott decision in 1857. There's an arc across time in our past for you. We're going to look now at a 20th century huge case, and that is Debs versus United States. And this is in 1919, and it'll allow us to look at what is fundamentally incitement speech to explore categorical definitional purposes and categories of speech that can be limited. So Debs was obviously a very well-known public figure. He'd received almost 1 million votes when he ran for president in 1912 on the socialist ticket. And then in 1918, Debs gives a speech outside the Canton, Ohio prison, and he'd been there visiting 3 socialists who were convicted of violating the Sedition Act, and they had been imprisoned. Now, the Sedition Act at issue here provides any disloyal, profane, scurrilous, or abusive language about the government of the United States, or the flag of the United States, or the uniform of the Army or Navy could be prosecuted. So Debs goes out, he speaks to 12,200 people outside this prison. He offers his support for the prisoners, saying they're paying the price for seeking to pave the way for better conditions for all mankind. He was a pacifist. He condemned the war, but he actually took care not to advocate any illegal activity, and even commented to his audience that he had to be prudent with his word choice. Nonetheless, he was arrested and convicted. He got a 10-year sentence. And he takes this up on appeal to the U.S. Supreme Court, arguing that it violated his First Amendment speech rights. And so let's look on the next slide at what had come down in the exact same term, and that's the well-known case of Schneck. And Schneck is a case, of course, that decided and adopted the clear and present danger test for speech looking at words in context. So, as applied to Debs, a unanimous Supreme Court, as written by Justice Holmes, held that even though Debs did not expressly advocate draft resistance, his intent and the general tendency of his words were together sufficient for a jury to convict him fairly. And in fact, in perhaps tragic irony here too, the Supreme Court even noted that, he had noted in his speech that he had to be careful what he said, and that showed an awareness that he was kind of in the zone of incitement, as opposed to seeing it as a sign of him actually being careful. Now, the same term we had Abrams v. Uys, and this is about 8 months later on, where you have a similar case of several individuals who are convicted of distributing leaflets advocating their political views about the Russian Revolution. They were convicted as offering clear and present danger speech. There, the conviction was affirmed by the Supreme Court, but this time Holmes issued actually an impassioned dissent. So we see here one of the categories of speech that gets exempted from First Amendment protection. Let's take a little quick sidestep here and talk about whether the First Amendment applies to the states. And this is the incorporation doctrine issue. And so the fundamental issue is that we have this idea that the protections of the constitutional amendments in the Bill of Rights had only applied to the federal government at the founding of the Republic. They did not apply to the state governments. And so the question then was raised, after the Civil War amendments were adopted, as to whether the 14th Amendment's Due Process Clause fundamentally incorporated those 10 amendments by reference and made them basically applicable to state governments. And this sort of question of whether we had this massive new reordering in our constitutional world after the Civil War amendments is answered by this basic test that the Supreme Court's adopted. And that is, they look to figure out whether the rights at issue in the Bill of Rights are fundamental ones, rooted in the tradition and conscience of our people, and therefore implicit in the concept of ordered liberty. If so, they get incorporated and applied to the states via the 14th Amendment. And that's sort of the test and quote from one of many cases that looks at this test, but the Griswold-Vive, Connecticut case dealing with contraception in the 1960s is one that sort of looks at it, and it's a good case to go look at if you want to get a better sense of the incorporation doctrine. And really all of the Bill of Rights, except a few portions of some of them have been incorporated and adopted. Now, the First Amendment has been one of the cases is another one of these cases dealing with left-wing manifesto. Here that was Gitlow v. New York, and there you had state prosecution for a left-wing manifesto publication and conviction. The court held it was incorporated and applied to the states. Let's turn back to substantive First Amendment principles now in the 20th and 21st centuries. Let's get our bearings on modern First Amendment principles. The court scrutinizes closely any sort of content-based or viewpoint-based speech restrictions. What is a content-based restriction? This is a restriction on speech that is due to the content of the speech. Here is an example: a law that restricts any type of political message from being expressed in a public place. And these get reviewed under strict scrutiny review, making them very hard to survive. Next, what is a viewpoint-based restriction? This is a restriction on speech that is due to the viewpoint expressed by the speaker. Here is an example: any law that restricts someone from expressing a specific political viewpoint, such as support for Donald Trump or Barack Obama. Finally, what are content-neutral laws? Laws that restrict speech in a content-neutral manner are generally analyzed under intermediate scrutiny, in that they must serve to advance an important government purpose and must be substantially related to that purpose. Example: an anti-littering law that does not on its face restrict speech, but incidentally does as a result of its neutral anti-littering application. Let's look at an example of a content-based law and the First Amendment. Here are our facts. In 2005, Gilbert, Arizona adopted a municipal sign ordinance that regulated the manner in which signs could be displayed in public areas. The ordinance imposed stricter limitations on signs advertising religious services than signs that displayed political or ideological messages. A local church would post signs on Sunday about the services in its church. It was then cited for violating the ordinance. The court held that the town's sign ordinance imposed content-based restrictions that did not survive strict scrutiny because the ordinance was not narrowly tailored to further a compelling government interest. Justice Thomas's unanimous opinion also clarified that strict scrutiny should always be applied when a law is content-based on its face. Now let us turn to an example of a law that is one that shows a viewpoint-based example. This brings us to a rock band. Here are the facts. an Asian American band wanted to register, quote, slants, end quote, as their name. It was, as the band explained, an act of reappropriating a slur to drain it of its historical negativity. There you see the rock band at issue also. Next, the Trademark Office denied federal trademark on the word, as it was disparaging, and such marks that may disparage cannot be registered under the Lanham Act. The Supreme Court held as follows: denying trademarks that are disparaging is a viewpoint restriction that fails the First Amendment. In short, it cannot reject a mark because of viewpoint it espouses. Here is the language. Our cases use the term viewpoint discrimination in a broad sense, and in that sense, the disparagement clause discriminates on the basis of viewpoint. To be sure, the clause even-handedly prohibits disparagement of all groups. It applies equally to marks that damn Democrats and Republicans, capitalists and socialists, and those arrayed on both sides of every possible issue. It denies registration to any mark that is offensive to a substantial percentage of the members of any group. But in the sense relevant here, that is viewpoint discrimination. Giving offense is a viewpoint. We have said time and again that the public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of their hearers, end quote. That is at page 22 and 23, and is a key framing of how viewpoint laws fall. Now we can see these principles at work in our next yoga war, the city of San Diego against public beach yoga. Let's unpackage the facts of the case. Again, the San Diego Ordinance from 2024 that defined teaching yoga as a non-expressive activity and prohibited the teaching of yoga in shoreline parks and beaches without the city's permission. Plaintiffs in our case were yoga instructors who taught yoga on the beach. Seemingly peaceful and innocuous, right? Helping people? Not to busy city legislators, it turns out, for plaintiffs were cited for instructing yoga on the beachfront park. They sought permits, but were denied a permit as the city would not issue such a permit. The ticket listed 2 violations. 1, use of public parks and beaches regulated yoga in violation of the law. And 2, they set up an exhibition and gave a lecture in violation of another part of the No Yoga Ordinance. Namaste indeed, City of San Diego. 2 days later, our plaintiffs filed a federal First Amendment action. They in turn sought a preliminary injunction. What did the district court do? The district court concluded that Hubbard and Back, those are our plaintiffs, had not demonstrated a likelihood of success on the merits because they failed to establish that the activity of teaching a yoga class is protected speech under the First Amendment. Bah humbug, district court. The district court further determined that, to the extent that it goes beyond directing or leading poses to discussing potentially the of yoga, that is an incidental effect on speech. Thus it found that the ordinance is not a content-driven ordinance, but rather is content-neutral, as the expressive activities that are excluded involve and incorporate many things. Our plaintiffs on behalf of public yoga took an appeal to the Ninth Circuit. Let's now turn to the Ninth Circuit. Would it, like in the copyright realm, save yoga for all? The Ninth Circuit framed the issue as follows. Is teaching yoga protected speech? Back to our First Amendment rules. The government, including a municipal government vested with state authority, has no power to restrict expression because of its message, its ideas, its subject matter, or its content. Pure speech is entitled to First Amendment protection unless it falls within one of the categories of speech fully outside the protection of the First Amendment. Accordingly, a person who teaches yoga is communicating and disseminating information about this philosophy and practice through speech and expressive movements. Like vocational training classes, plaintiffs' classes aim to impart a specific skill and communicate advice derived from specialized knowledge. Therefore, it held as follows. Quote, the First Amendment protects teaching yoga. An individual's right to speak is implicated when information he or she possesses is subjected to restraints on the way in which the information is disseminated. End quote. So far, so good. But the city also argued that it could regulate the expressive content on its beaches as it had as a location, time and manner restriction, and that there were coastline erosion issues that mattered. Before we answer these questions, let's listen in on the Ninth Circuit and their oral argument questions of, first, the San Diego City Attorney about the issues.
Of yoga is a particularized message and exhibits the likelihood that it would be understood. I think
Can you answer the question that I asked at the outset, which is why is yoga singled out here of all the things that could be taught in a park? You could teach Shakespeare, you could teach Tai Chi, as I think Judge Sanchez will ask you about. You could teach anything, but what's it with yoga?
Well, I'll just answer it this way, Judge Thomas. It wasn't singled out in the sense that that's what is actually barred. It was provided as an example of the services that can't be provided without a permit. And in this particular instance, as a matter of fact, I'll point out to you right now that
But the statute doesn't say, for example, yoga. It specifically, it looks like yoga is being targeted here in some way. I'm just curious. I think maybe we all are. What happened here that?
Well, the issue, the city of San Diego has numerous beautiful beaches, and obviously engaging in activities such as yoga, other activities on the beach, it's a highly sought type of activity to do. But what the statute does, the ordinance, it doesn't directly regulate yoga. What it does is it requires individuals who want to have classes or any kind of commercial activity on the city's beaches to actually go and request a permit for a number of different reasons.
But it says that teaching yoga is not an expressive activity, so it is directly targeting yoga. It doesn't talk about teaching anything else, and there are a million things that you could teach.
Right, but if that's even the case, Your Honor, let's assume here for a second that yoga is expressive activity. The city still has the right to regulate in an appropriate time, manner, and place restriction how that's taught. And that's actually a fairly straightforward analysis of any kind of business that the city can permit. And I just want to clarify here. The clearest example that yoga is not, in fact, targeted is that they can teach it. And you can see even in appellant's briefing that if there's 3 or less individuals, there's no permit required. Any activity
But counsel, that let's say you have 8 individuals that are being taught Tai Chi for free. Is that something that someone would need to get a permit for from the city under your view of the ordinance?
This specific one, no, because it doesn't fall within the strict language of subdivision C14.
So then doesn't that illustrate that yoga is being singled out? Because, I think you've got a bit of an uphill climb to say that teaching a certain subject matter that involves movements and the history and philosophy behind it is not expressive. It seems, as we've been coming up with examples, there are many instances where you're teaching something you're speaking and you're expressing things about that subject area. And if you just said that Tai Chi would not be subject to it, I have a hard time seeing what the difference is between one type of activity versus another.
Well, what I was pointing out is that your example for the Tai Chi isn't specifically addressed.
There you heard some tough questions on why yoga was being singled out and given the comments of the judges. You can probably see how this one was coming out. But now let's listen to some follow-up questions for the yoga instructor's lawyer.
It's like the city is just relying that this is commercial speech and doesn't constitute expressive conduct in any way that puts it outside the realm of commercial speech.
Well, the declarations made clear that the plaintiffs and others offer free as well as donation-based yoga classes. The donations are secondary. These are professional yoga instructors. They teach in studios. They have jobs. This isn't their sole source of income. They're out there. They state this in the declarations that they're teaching these classes, or they were teaching these classes, to give back to the community, to speak to a wider audience. They don't want to just spend their Saturday, teaching yoga to 3 people. They want to offer it to the community, and it's a way for people.
But even if it's, I guess if it's economically, there's some economic aspect to it. Does that matter here, even if it's commercial speech.
That's not what they're being cited for. And we do go through the case law on that even soliciting donations, that is protected. There are other activities in there that have some type of a solicitation or donation purpose that are permissible or that are protected under the First Amendment. But that's also not what the plaintiffs are being cited for. They're being cited for the actual teaching of the yoga. And we have on 3 ER 322 of the record, subsection C24 of the ordinance regulates large groups. So if you have more than 50 people showing up in unison and doing something, unless it's expressive activity, they need a permit. So if people are just spontaneously showing up and doing yoga without anybody leading them, or perhaps Tai Chi, if it's more than 50 people, it's going to fall under that. But if it's more than 4 people, if there's somebody leading them, just the mere fact that there's somebody that's actually speaking and leading the group, that person is going to be cited. So it's not, and there's no agreement, there's no prior agreement for people to, negotiating this in advance that they're going to show up. The instructors go out, and this is in the declarations, anybody can set down their mat anywhere. It's just like any other use of the park. And the yoga instructor is simply offering instruction. People can show up or not show up. It's not arranged in advance. I don't know what the city was referring to with a QR code. That's not in the record. There is talk about coastal erosion on 2 ER 71 of the record. There's a photograph of the rangers driving their 2 giant trucks right onto the area where Ms. Bach had been teaching her classes. So the idea that people practicing yoga on that area is going to somehow erode the cliff is also a red herring.
And so there you see the issues as debated in the court at oral argument. From there, let's see how the court ruled in the analysis. The operative rule of First Amendment law was as follows. The First Amendment affords special protection to places which by long tradition or by government fiat have been devoted to assembly and debate. The beaches and parks are traditional public forums. Now there is an exception. Even in a public forum, the government may impose reasonable restrictions on the time, place, or manner of protected speech. But content-based laws, those that target speech based on its communicative content, are presumptively unconstitutional and may be justified only if the government proves that they are narrowly tailored to serve compelling state interests. It must meet strict scrutiny, that is. How did this play out then? As applied, the ordinance was content-based on its face. The plain language of the ordinance defined regulated speech by particular subject matter, drawing distinctions based on the message a speaker conveys. It is unlawful to provide any service or to require someone to pay a fee before providing a service, even if characterized as a donation, and specifically identifies yoga as an activity that constitutes a service. In this strict scrutiny world, the city's asserted compelling interest was as follows. The rule furthers the city's substantial government interest of preserving the city's parks and beaches for the public. Did that pass muster to ban yoga? Place your yoga bets now, and let's listen in on part of the appellate oral argument before we get the answer. If you voted for public yoga, then you were right. The court said as follows. To defend its prohibition on teaching yoga, the city cites its important governmental interests in protecting the enjoyment and safety of the public in the use of its shoreline parks. The city argues that allowing Hubbard and Bach to teach yoga at shoreline parks would lead to harmful public consequences to the city's safe and effective regulation of its parks and beaches. Although public safety is a compelling interest, even assuming for the sake of argument that public enjoyment is as well, the city has provided no explanation as to how teaching yoga would lead to harmful consequences to these interests, or even what those consequences might be. The city therefore cannot demonstrate that its prohibition against teaching yoga is narrowly tailored to meet its interests. And the ordinance does not prohibit teaching various other subjects to 4 or more people in shoreline parks, including those that, like yoga, potentially involve physical movement. Thus the Ninth Circuit held, quote, because the city has demonstrated no plausible connection between Hubbard and Bach teaching yoga and any threat to public safety and enjoyment in the city's shoreline parks, the ordinance fails strict scrutiny, end quote. Yoga for all, well, it won again. So there you have it. I think we can safely say, and I'm guessing many of you are not shocked, that the Ninth Circuit is the yoga-friendly circuit. In the yoga wars, the Ninth Circuit has saved and preserved easy access to yoga for all. Namaste, Ninth Circuit, and thank you. Let's now run through the recap of our conclusions from today's program. We did an overview of copyright law so that you have all the basics of copyright, and we saw the idea of health-based sequences in yoga not being subject to copyright protection. We explored the critical idea and expression line, whereby a particular expression may get protection, but ideas that inhere in that expression are not subject to copyright. Then we did an overview of First Amendment law and its tests and boundaries, and we saw that a city ordinance barring yoga from beach parks, but not other exercises like Tai Chi, fell as a content-based restriction on expressive activity. And here's the bottom line, the takeaway for you as you advise your clients. While the specific manner in which an author expresses the concept of a process or idea may be subject to copyright protection, that copyright protection does not extend to the idea or process itself. So, Einstein's theory of relativity paper, if written today and in the USA, could be copyrighted. But the idea of E equal mc squared is not his to control. And the takeaway from the City of San Diego case is that city laws banning yoga, but not other group exercise events, are content laws aimed at expression and are unconstitutional. More fundamentally, why on earth does a city care if people lay out their mats and do yoga? But that is for another day and perhaps another program. For us today then, go do your yoga safely, and what is more, you are legally safe to do it on the beach. Stay curious, and as always, if you have any questions, please feel free to reach out to me.